Hello. On behalf of Irwin Mitchell Solicitors, I am delighted to welcome you to this WebEx training session on the General Data Protection Regulations, which come into force in May 2018. My name is Jo Mosley and I'm your host. I am joined by my colleague Elaine Hutley, a senior solicitor in our national employment team. GDPR is the biggest change to data protection law for a generation and will require significant adjustments to be made to the way in which you handle information about your staff. Getting this wrong will expose your businesses to huge fines and reputational damage. It is therefore important for businesses to start preparing now, and Elaine will explain the steps we recommend that you start to take.
Thanks, Jo. As Jo mentioned, GDPR comes into force in May 2018, and it might be tempting to put off preparations to deal with GDPR, but it really is a huge undertaking. It marks huge change in data protection laws, and our advice to clients is to start sooner rather than later. The GDPR harmonises data protection laws across Europe, and it updates the current regime, which is over 20 years old. If we think about the changes in terms of globalisation and technology, it's no surprise that GDPR introduces whole-scale change rather than small tweaks here and there. It introduces new rights, larger penalties where there is non-compliance, and also a new accountability principle, which means that the data controller is responsible for and has to be able to demonstrate that they have complied with the relevant data processing principles. If you think about how data was stored 20 years ago, it's no surprise that this really is a change in approach and a real step up in terms of the consequences of getting it wrong. It's also no longer a commercial issue. Data processing isn't just done by your commercial teams or your sales teams. It affects everybody in all walks of life, and therefore in HR you are at the forefront of that in terms of business compliance. GDPR not only applies to EU companies, but any company that processes personal data of individuals in the EU, and that will also include the UK post-Brexit. Generally, GDPR is attracting huge amounts of publicity. Some is true, some is pure myth. But that, coupled with the fact that individuals are now highly aware of their rights in relation to personal data, means this really is a top priority and high up on any business's agenda. Now, GDPR, as I've said, is a very wide set of regulations which impacts on all areas of the business. It's not the purpose today to cover it in full. We really are focusing on the HR and the employment aspect. This isn't a detailed seminar on GDPR either. We couldn't do that justice in sort of half an hour, but it's intended to give you a heads up as to what you should be considering as the key points, and also how you should be approaching it at this stage and what steps you can take now sooner rather than later. So why is GDPR relevant to you as the HR team? Put simply, HR have a responsibility for handling massive amounts of personal information which relates to the company's employees, including any job applicants and also former employees. HR are also often at the forefront of risk and compliance in relation to the employee or the applicant's personal data, and are therefore directly affected by the changes that GDPR will bring. Having said that, it isn't your sole responsibility. Data protection is such a topical and sensitive issue that responsibility really has to lie at board level as well. And therefore, in addition to working out how you are going to comply with GDPR, part of that will be how does the business communicate between the various teams and also reporting upwards to the board. Within the business, everybody needs to be involved and to understand their roles and responsibilities. This isn't limited to the HR team, but also to line managers, for example, in identifying and understanding what personal information they may hold locally, not just centrally on employee files, and what their obligations are, in terms of processing that. So what are the key changes that GDPR brings? A significant change is that now the definition of data is much wider. Because of the changes in technology, for example, an IP address is now considered to be data, whereas under the Data Protection Act that wouldn't have been the case. The data is any data from which a living individual can be identified, so much, much wider because of the advances in technology. We also, to deal with the increased obligation, have to have more procedures and policies, because you are expected to be proactive and not reactive in understanding and analysing the information that you hold and why you may need to keep it for whatever period of time is relevant for your business. Because it's acknowledged that the amount of data that businesses hold has grown, you're subject to increased scrutiny. And the ICO are going to be taking more of an interest in data that's held, why and how it's processed, and the consequences of getting that wrong are increased financial penalties. Under GDPR, a fine can be up to £20 million or 4% of an undertaking's global turnover. Previously, under the Data Protection Act, most businesses would have relied on the employee's consent to process personal data. The one question that we're often asked is whether employees can continue to consent to the processing of their data now under GDPR. The short answer is yes, consent is still applicable. The longer answer is, but you shouldn't rely on that on its own. The reason for that is if we look at what is necessary for an individual to give consent, consent has to be unambiguous and freely given. Unambiguous means that the individual has to have absolute clarity and a clear understanding of what information is being held by them and why. So if you looked at your policies and contracts as they currently are, I expect you would have a short paragraph to confirm that the individual acknowledges that we will hold personal and sensitive data about them and they agree to the processing. That isn't sufficient any longer for consent. If you want to rely on consent, you would have to break it down to identify each individual piece of data that you hold on employees, give an explanation for each individual reason that you will process it, and for each one of those the individual has to give knowing consent. That has to be exhaustive. It can't be a list to demonstrate or give examples. So it really is an onerous task to rely solely on consent. There's also a question mark, even if you were to give that comprehensive list and to get consent for each individual processing point, is whether an employee can freely give consent. Because they are much weaker in the bargaining position between the parties. They're reliant on the business for their employment, for their monthly or weekly wage or salary. And even if you were to comprehensively set everything out, there is a question mark as to whether that consent is freely given. And you'd also, even if you were to go through that process, you'd have to keep it updated and regularly reviewed to make sure that the list never became outdated. So our advice is don't rely on consent alone. There are other grounds that an employer can use to justify the processing of personal data. If we look at the alternative basis for processing, on the slide there in front of you, you will see we've got consent at the top in brackets because of the health warnings that I've just given. We then have other grounds, including the legitimate interest of the data controller, the necessity to form a contract, compliance with a legal obligation. These are all ones that employers should be able to easily rely on, because, for example, if you don't process personal data in relation to an employee and, for example, their bank account, you can't then pay them for the work that you do, which you are legally obliged to pay them for the work done. And it's necessary in the performance of a contract. So as we will come on to explain shortly or discuss in further detail, the next steps that you can do is to complete a data audit to identify what data you hold and why, and then it's important once you've done that to reflect on these alternative bases for processing the data. So for each occasion you have a legitimate interest which isn't necessarily predicated solely on consent. Having said that, it's always useful to have a backup argument. So we're not saying don't have consent at all. It's always useful where you can and to the extent you can to have an employee's consent. It just shouldn't be your only ground for justifying the processing of data. So moving nicely on, the next question that arises of, well, what can you do now is the question, well, do you know what information you have relating to your staff? And have you ever questioned internally why it is that you are why you are keeping it? So the first step that you can do in preparation for GDPR is to carry out a data audit. This is for you to take a step back and to understand and identify the data that you hold in relation to employees, applicants or former employees, and to assess what your obligations are under GDPR and how long you should be keeping that data as against the principles, as we've just discussed, to say, well, what is the justification that you have for holding and processing that data? As part of the data audit, you should consider whether it's possible to include within any policy consent to identify what exactly it is you hold, why you hold it, and get the individual's agreement to it. That might not be for all types of data that you hold, but as I've said, consent is helpful to have to a certain degree. As part of the audit, you'll then also need to think about how long you hold the data. In our experience previously, employers have held all data for one defined period of time, and it's usually around 6 or 7 years. And that was never really questioned. Employers would say, well, they held it for that length of time and then it's destroyed. There is a certain logic to that. For example, employees can bring a breach of contract claim for up to 6 years post-employment. And so that tended to be the yardstick that was used. That isn't sufficient any longer under GDPR. So once, as part of the first step of your audit, you identify what information you hold, you then have to consider for each type of data how long you should hold it for. So if you were being incredibly thorough under GDPR, you would hold different types of information for different periods of time. And we also recommend that you will have a data retention policy which would clearly set that out and would be accessible to employees as well.
Elaine, has the Information Commissioner given any guidance yet about how long particular pieces of employee data should be retained?
We are waiting for the finalised version of the Information Commissioner's guidance. It's due to come out. We've been told in the new year, but it's likely that that might slip. But given that the GDPR regs come into force in May, it will have to come out at some point in the first quarter.
We're anticipating that it will provide some guidance on.
Yes, yeah, definitely.
Thank you.
Okay, so once we understand the data that we hold for staff and why and how long we will keep it, we can then look to say, well, how do we understand the enhanced rights that staff will have? Much of it is similar to the provisions that we currently have under the Data Protection Act. So, for example, there's the right to be informed. This is all about transparency of information. So we'll have policies and procedures whereby employees can understand the information that we hold and the reasons for it. There's a right of access. So this is the subject access request that we currently have under the Data Protection Act. We'll come on to those and what they will look like under GDPR in a few moments. the right to rectification. So if employees understand and can see and have transparency about the information that is held about them, but they realise that there's an error, they have a right to correct that. There is a new right to data portability, and this is all about the advancement in technology, where it's more difficult to envisage in the employment scenario, but for example, in the consumer sector, if a bank holds lots of data about you, there is a suggestion that they should be able, that data should be portable, such that if they wanted to change bank accounts, they could go to their new bank and take all of that data with them. So it's about streamlining and efficiency. It will be interesting to see how that progresses and develops in the employment context. There's also a really interesting right to be forgotten, and there's been a lot of press coverage about this in employment journals and commentary to say, well, can an employee, for example, make a right to be forgotten, make a request to be forgotten if they've just been subject to a disciplinary warning? And the short answer to that is no, because we have a genuine ground to retain that information and that data, because it's part of our ongoing employment relationship. So there was a lot about that, but again, this was one of the myths and lots of speculation, which actually nothing fundamentally changes.
How do you think that might apply in an employment context?
I think it will be limited in an employment context. I can see that for past employees, they might say, I don't want you to hold my data for 7 years. I have a right to request to be forgotten. And then we go back to the alternative grounds for processing data and say, well, why do we need to keep it for that length of period? They only have a right to request to be forgotten, not the right to be forgotten itself.
Right.
So we don't have to go through the process to say, do we really need to keep it, or actually should we delete that data? But in terms of current employees, I guess there's a possibility that they could say once a disciplinary warning has expired, they could make the request at that point. But a question mark arises, or should arise when you're doing your data audit, to say, should we actually be deleting warnings once they've expired, or once they've expired for more than 2 years? It's a question for every business to apply their own rationale, and we can obviously provide more advice on a case-by-case basis.
Thank you.
Okay. In terms of the right to be informed, if you don't already, under GDPR, there is an express obligation for you to issue job applicants and employees with a document detailing what type of information about them is or will be processed or stored, on what legal basis we justify that, and what their rights are in relation to the information. And that's called a privacy notice. Some employers already have them, or already have the equivalent. Maybe it's not labelled as a privacy notice. If you don't, this is something that you can start to think about sooner rather than later. So it's a proactive step that you can take now to be prepared for May 2018. If you do already do this, you just need to review it, because the requirements under GDPR are more detailed. It's about being more comprehensive, being more thorough, providing transparency and information to employees. So even if you have them, you should still review them. Notices should also be issued when the data is first collected, so it should be to applicants as well, and it may be possible when you are recruiting, for example, to enclose a copy of your policy if you're recruiting via an agency or a recruiter, to provide them a copy to provide to employees. If you do it yourselves through your website, then it should be available on your website as well. And employees or applicants should be referred to that in your communications with them to make sure that they understand it. Okay, so what the privacy notice will include is the legal basis for processing the data, how long their data will be kept for, if it's ever transferred anywhere out of the company, to a group company, to a third party, they should be notified about that. You also have to inform them how they can make a subject access request and about their rights to complain to the Information Commissioner's Office. So we mentioned before briefly the right to be forgotten. And in the employment context, as we discussed, this can be when the data is no longer necessary, so it can be from a former employer. It could be in the case of if we don't have a legal ground to process data other than consent, the consent can be withdrawn, and that can be coupled with the right to be forgotten, which is another reason as well why we shouldn't be relying on consent at all alone, because it is a right that can, or it is something that can be withdrawn. Where data is unlawfully processed, there's a right to be forgotten, or to comply with legal obligations. I'd now like to go on to discuss subject access requests, because aside from GDPR, this is something that we have seen an increase in. And it used to be the case many, many years ago that if a subject access request was made, it was on the whole because there was some sort of dispute or employment tribunal proceedings. And a lot of the time, subject access requests would be made very early on, maybe at the time when the claim was first being lodged, and it was a bit of a fishing expedition. And many years ago, it was possible for an employer to say, I'm not responding to that subject access request, because it is simply that. It's just part of a fishing expedition. And if you want to bring a claim, there is the appropriate point in those proceedings that you will be provided with any documentation and information that we hold. And that has slowly been changing such that now if you receive a subject access request under the Data Protection Act, there is very little that you can do to avoid it or not to send a comprehensive response. In very basic terms, under the Data Protection Act at the moment, individuals, employees are entitled to receive specific information that you hold about them in an intelligible format within 40 days of a request. Employers do have the right to charge a £10 fee for the administration costs of complying with the request, but generally that £10 fee won't scratch the surface, because to receive and to process a subject access request is incredibly time consuming given the advances in technology. So it's no longer acceptable just to send a copy of the individual's hard copy personnel file. You have to go through IT systems, not just those that are held centrally on a HR database, but to look and see whether managers have exchanged emails, whether other employees have exchanged emails that would identify that individual. So it can be costly and it can be incredibly time consuming. Under GDPR, an employee will have enhanced rights to access their personal data. So they are now entitled to a wider class of information that you hold about them, because, as I've explained, the definition of data has been expanded. The GDPR regulations also reduce the time limit for employers to provide a response. So whereas previously or currently under the Data Protection Act it's 40 days, now an employer has to respond in a timely and reasonable time frame, and it's envisaged that that won't be any longer than 30 days.
And that's 30 actual days, not business days?
Yes, 30 actual days. And this is really tough for businesses, because the obligation on the employer has increased because the volume of data that you now have to identify and find and provide has increased, and the time frame in which you have to do it has reduced, and you're now no longer even able to claim the £10 fee. So it really is very important when we are educating staff that managers understand what a subject access request is, so that they can identify it and pass it on to the relevant person who will then progress it, whether that's your HR team or a compliance manager, because time is of the essence. You can't afford to lose a couple of days or a week from that 30-day deadline, because 30 days is seen to be the maximum. The requirements are that you respond without delay.
Does it have to be on a particular form or use a particular expression?
No, not at all. You might, as part of good practice, have a subject access request form for employees as part of some of the new policy documents that you'll put in place, but that doesn't mean that the employee has to use that in order for it to be valid. It's a bit like a grievance. A grievance can be an email, it could be a comment in an appraisal form. You know, we will take or a very, very wide view of what a subject access request is, and it doesn't have to have that title on it.
But it does have to be in writing?
It does have to be in writing, yes. It's really important that you understand and that you have a plan in place for what will happen once a subject access request is made, because you will have to jump into action straight away. So your IT teams need to understand where they will look, how they will look, the types of search terms and parameters that they will use. Because once all that information has been mined, you then going to have to go through it so that any personal data about any other employee is then redacted. So the process from receiving a subject access request to identifying what data you hold, to then reviewing it and redacting it where necessary before sending it out can easily take a couple of weeks. So what can you do to prepare for these enhanced subject access requests that you will receive? The first is set policies and procedures. You are under a positive obligation to make employees aware that they have the right to make a subject access request. It isn't something that you can hide from, so you may as well be prepared and proactive about it. Plan how to handle them and to ensure that everybody understands the new timescales. Make sure that people are trained, managers, IT teams. You can make your life easier if you can get your managers to store any information about employees centrally where they're meant to, so discourage bad behaviours about managers having their own personal files within email folders or on their desktops, because that will just complicate things. Develop template response letters, understand what it is and how it is that you will respond. It's a starting point that will get you ahead of the game. And assess as part of your audit whether it's worth considering changing the way that you store data that will make it easier in the event that a subject access request is received. Under GDPR, as I mentioned at the outset, GDPR introduces a new accountability principle which places a proactive obligation on employers to ensure compliance. So much of what you can do between now and May is to identify how you can prevent data breaches. So this will be not only your data audit and planning for subject access requests, but completing risk assessments to understand where you hold data and where you may be at risk of non-compliance with the GDPR principles. It will most definitely include training, because all staff will need to understand what GDPR means, and then there will be further enhanced training for your line managers or senior individuals within the business so that they understand their obligations as well. Planning, review your audits and your assessments and your internal processes to make sure that they stand up to scrutiny and that they comply with GDPR. And as part of that, you need to test them to make sure that they actually work in practice and not that theoretically they should. And then think how you will respond to requests. So subject access requests are the most obvious, but also think about how you would respond, for example, to an individual making a request to be forgotten, or if there was a breach, how would you report that? And how can you mitigate against the consequences of a breach? So there's three areas there that you should be reviewing everything that you do as part of your HR processes, and you can do that now in advance of May. And whilst the guidance from the ICO might add further detail, you'll be really ahead of the game for implementation. In terms of next steps, just to recap on some of the things that we have discussed, carry out your data audit, be prepared for subject access requests, consider whether you need to appoint a data protection officer. This will only apply to large businesses. In the main, most won't meet the threshold. Consider what policies you currently have in place and review whether you have any policies that are missing or whether the policies that you have are sufficient and where they need to be updated, and carry out staff training. It's important that when GDPR comes in May 2018, that either immediately in advance of that or on that becoming effective, you have some sort of training ready to roll out. Tailor the training to the right level of employees. It is unlikely that one size will fit all, because you will want all of your employees to know that GDPR has come in and what your approach to it is, but then you'll also need more enhanced training for your managers who will be involved in implementation or responding to requests, etc. And then you might need further specialised training for anybody, for example, who will be involved in subject access requests.
And of course we could provide that as a...
Yes, we can certainly help with that. It's never nice to think about it, but you will also need to plan for data breaches. Notification of data breaches is compulsory, which is one of the biggest changes from GDPR at the moment. Under the Data Protection Act, there isn't necessarily in all cases a requirement for you to report breaches. Now, because there is an acceptance and a heightened sensitivity to breaches of personal data, there is a positive, proactive obligation on businesses to report. The only exception to that is where it's unlikely to result in a risk to the rights and freedoms of an individual. But the threshold to reach that is going to be incredibly high. So if ever there is a breach and you question whether you need to report it in the future, please do take advice on it, because it's something that the ICO are going to take a really dim view of. And if ever a business tries to say that they're relying on that exception, the process and the decision making is going to be really carefully scrutinised. The ICO also has to be notified of a breach within 72 hours, so there really isn't a lot of time to delay before making that decision of whether notification is necessary or not. And businesses also have to keep a register of any breaches. So if this is an employee has lost their mobile phone or a laptop is left on the train, anything like that has to be included on the register. And some of the commentary that has been circulated about that register is that the ICO, if ever they came out to do an audit or asked to see your register, if there weren't many breaches on there, they would think that you're not properly recording, because to a certain extent there's an acceptance that human error will happen, and the ICO would rather see a comprehensive list that shows that the company is monitoring it and they're taking it seriously and they've identified any trends and took steps to mitigate that against that, for example, passwords or encryptions on devices, rather than there being a denial that, but we never breach, because they've said it just won't happen. People will always, as a matter of human nature, make mistakes.
Well, that's interesting.
Yeah. In that context, we also have to think about breach to say, well, what are we going to do about there being a breach? So it might be necessary as well to review things like disciplinary policies or annual performance reviews, to consider the secondary or ancillary impact of breaches, to say, if it's serious enough, will we treat it as a disciplinary matter?
Thank you, Elaine.
I was going to say, that is a whistle-stop tour through some of the things that you can start thinking about now, and it really is worth investing the time.
We also have a short note about the top tips which will help you prepare. If you would like a copy of that, my email address is on the slide. Please let me know and we can get those mailed out to you. We've found that the people that have looked at these found them incredibly useful because it does sort of streamline exactly what you have to do and the steps that you have to take. And it's a good aid memoir, if nothing else. Anyway, we hope that you've enjoyed this webinar. There'll be others on this topic of a more general nature, and you'll be notified about those in due course. Many thanks. Goodbye.